The reasonable doubt doctrine, also known as the benefit of the doubt doctrine. What is it? What does it all mean? There is this thing in the law called a burden of proof. Now, a burden of proof is what fancy lawyer word, some $100 lawyer word, basically what it means is it's what you have to prove to win your case. And they say burden because only one person, one side, can carry a burden in a lawsuit or in a claim. And so if your side, as veterans do in most scenarios, has the burden of proof, then you have to submit certain things and prove certain things to a certain evidentiary degree. Okay, and we're going to talk about what that means in a minute. But we have, as veterans and claimants and survivors, the burden of proof in VA claims. So, back way before 2000, so 2000, the Veterans Claims Assistance Act, the VCAA, was passed. It kind of expanded the law, created some different duties that the VA owes to the veterans. It really was what we call in the law a liberalizing rule of law, because it kind of opened up the field to some new areas that are still being considered even 17 years later. Before that, our burden of proof, so prior to 2000, our burden of proof was that we had to show that after considering all the evidence, there was an approximate balance. Oh no, that's the new one. A claimant must submit sufficient evidence to justify the claim is well grounded. So it was a sufficient evidence, and what you're showing is not sufficient evidence of each of the elements. You're showing sufficient evidence that it's well grounded. So it was a pretty high burden of proof. That changed. There was one exception to that, and it was this benefit of the doubt rule. That changed in 2000. And in 2000, the Congress struck out that well-grounded claim basis. And what it said was, all it left was, after considering all evidence, where there is an approximate balance of positive and negative evidence regarding one of the four pillars, and they didn't say four pillars, that's me shortening the language. They probably should have. It probably would have been a lot easier for folks to understand if they just used my language, right? In any event, the veteran gets the benefit of the doubt. I would argue, and my arguments obviously were on the losing side, but I would argue that that language flipped the burden of proof to the VA, that they had to show a preponderance of evidence that there was not support for the claim. But that said, the courts didn't agree with that analysis. I never put that analysis before the courts, but they did not read it that way, and they read it instead as creating a new-ish burden of proof. And what that has largely grown to mean over the last 17 years is that here's what veterans have to prove. The veteran generally has the burden of proof and persuasion. There are legal nuances between the burden of proof and persuasion. The veteran need only prove that each element is at least as likely as not, right? They need to, this is another way that folks say it, is that the VA can only deny the claim if the preponderance of the evidence is against the claim, and if the facts are in equipoise, another $100, that's actually a $500 word because lawyers don't even know how to pronounce it. But if the facts are in equipoise, the veteran gets the benefit of the doubt. So how does this all work? Because none of those words appear in the statute. If you go to read 38 U.S.C. 5107, none of those words that I just gave you that are the governing standards appear in the statute. All it says is, after considering all the evidence, there's an approximate balance of positive and negative evidence regarding one of the four pillars. The veteran gets the benefit of the doubt. Now, they say it in fancy legalese, but they never use any of those words. They never use preponderance. They never use at least as likely as not. They never use equipoise. None of that. It's all interpretation of that statute. And I'm not saying right or wrong. I'm just telling you what it is. So, a lot of veterans get, and frankly, a lot of attorneys, when they first start out, get kind of confused about this. So, where the VA went from there is they take the statute. They took 38 U.S.C. 5107, which basically said the language I just said. Your burden of proof is approximate balance of positive and negative evidence. Veteran gets the benefit of the doubt. And they wrote a regulation. So remember, if you've read the blog, you know this. And the link will be in the show notes about the 10 different rule books. Start out with the United States Code, USC. That's the law written by Congress. The next tier down is the CFR, the Code of Federal Regulations. That's what executive branch agencies use to publish the rules that interpret the statutes, right? Because remember, from all the way back in how a bill becomes a law in the branches of government, the Congress passes the laws, the executive branch executes them. That's exactly, and then the judicial branch interprets them. That's all the separation of powers is. And so the Code of Federal Regulations, or the CFR, is the executive branch's attempts to say how they are going to implement the law that Congress passed. And so 38 CFR is Title 38 Code of Federal Regulations. 3.102 talks about this reasonable doubt doctrine. And what they've done something very crafty there. And it's so well entrenched now, I don't think it's going to change. And frankly, I read things a little bit differently than a lot of folks, so I'm definitely in the minority on this viewpoint. But what the reg says is undisputable. What it means is where I'm in the minority. But here's what it says, is that after consideration of all the procurable and assembled data, when there's an approximate balance of positive and negative evidence which does not satisfactorily prove or disprove the claim regarding one of those four pillars, reasonable doubt will be resolved in favor of the claimant. Now, what they've done is they've taken that language from the statute that says approximate balance. Approximate is not perfect balance, right? It teeters and totters back. And they basically flipped it into a reasonable doubt standard, which is, I would argue, a little bit harder standard. But where veterans and survivors and some early attorneys doing this work and some VSOs get confused is we read that and we understand the plain language, which says, if there's any doubt, the veteran gets the benefit of the doubt. And that's what we think, is that all we got to do is get enough in there to create the doubt that it could or could not be, and then we win. Well, I will tell you that that's not how the VA works, and it's a dangerous way to work your cases. So there was a case, and they always have these horrible names that are so difficult to pronounce, and so to this veteran, I apologize for butchering your name if I'm pronouncing it wrong. I'm going to break my arm, pat myself on the back if I got it right, so I'm covered either way. But the case was Hawk versus Nicholson, and it's 403 Fed 3rd 1303. It's a Fed Circuit 2005 case. The link, or at least the citation, will be in the footnote or the show notes. In that case, the veteran argued that the VA can't weigh evidence where the evidence was not contradicted or impeached. What did that mean? That basically meant when the veteran put information in there and the VA had nothing to counter with it or to say it's wrong or to prove it's wrong or to argue that it wasn't being interpreted correctly, then they couldn't weigh the evidence. There's nothing to weigh. It makes sense in a way, right? The Fed Circuit came down, and this is important, and that's kind of some of that stuff was a little bit too much information. What the Fed Circuit came down and said was, you're reading it wrong. To get to that benefit of the doubt doctrine, there has to be a factual predicate. What does that mean? You got to have two things. Two things have to be shown in the facts before you get benefit of the doubt application. The first thing that needs to be shown is that all of the procurable and available or assembled evidence was carefully reviewed. First thing. So once you've got that, then somebody has to find that there's reasonable doubt about how that evidence is interpreted or the conclusion that it comes to, right? And so that essentially means that to get to the benefit of the doubt, you have to have a decision maker at the VA decide that they've got all the evidence, they've carefully reviewed it, and there's doubt, right? Let me make a parallel that probably makes it a little easier to understand. Baseball. Who knows the tie goes to the runner rule? For those of you that don't know baseball, batter hits the ball, shortstop fields the ball, shortstop throws it to first base. If the ball gets to the first baseman's glove and the first baseman's touching the base, if all that happens before the runner touches the base, runner's out. If the runner gets there first, runner's safe, stays on the base, right? And then can get moved around to score. If they get there at the same time, if the ball hits the first baseman's glove at the same time that the runner's bag hits the foot, the umpire says it was a tie. And the rules say the tie goes to the runner. But you see what happened there in the middle is that the umpire has to call the tie. Now, we all know, and this is one of the reasons that we got this replay thing in baseball. I don't know which side of that argument you fall on. It doesn't matter. But we all know that that came about because there were some big problems with rules just like that being not applied because the umpire didn't believe there was a tie. And the video showed something different. And so we know that the subjective observation of the umpire on the field was not always accurate. and therefore the rule was never applied. Same exact thing is happening in the VA. The VA rater, the decision review officer, or the BVA judge has to look at all of the procurable, all the evidence you can get, and all of it that's been assembled, do a careful review, and then, just like that umpire, they've got to decide that there's reasonable doubt. And how often does that happen? Not very often. Here's the takeaway. If you are arguing for application of the benefit of the doubt doctrine, which the court has told us is not your burden of proof, all it is a doctrine that breaks the tie in the evidence. If you're arguing that, you've already lost. You've already lost the case. What do I mean? Because somebody has already said that there is reasonable evidence in the record to deny the claim. They've also said there's reasonable evidence in there to grant it, and therefore at that point it gets resolved in your favor. But if you're arguing that, you have to concede to get there. You have to tell the rater, you have to tell the DRO, you have to prove to them the things that hurt your case. You have to show them that there's favorable or unfavorable evidence that could go against your claim, and that that's in perfect balance with the favorable evidence that supports your claim. And who wants to make that argument? Who wants to shoot themselves in the foot? There's a better way to do it. There's a much better way to do it. Here's the way you want to do it. You want to put in more evidence than you could possibly need. A preponderance of the evidence. And preponderance, in the law, it's got a very special meaning, and they teach us this in law school, is that, if you've got a scale that's perfectly balanced, a preponderance of the evidence is just enough to tip it in one side or the other. It's one feather past 50% is generally the easiest way to describe it. But I like to have a little bit more clear and convincing is a much higher burden of proof, and that's somewhere around, if you think of this as percents, like 90 to 95% certainty that a fact is true is clear and convincing evidence. That's not how the law works, but that's a good way to think about it. The preponderance of the evidence, they'll teach you it's just one featherweight past 50%, but I would argue it's somewhere in the 60 to 80% range. If you can get enough evidence in there to have 60 to 80% certainty that this fact is true, weighed against the other evidence, you've shown a preponderance. And if you can show a preponderance of the evidence, you're in a much stronger position, because then your argument is not, hey, BVA judge, there's some negative evidence in here, but it's in perfect balance with the positive evidence, therefore I get the tie. Instead, what you're arguing is you're saying, yeah, there's evidence in there that goes against my claim, but it's nonsense, it's bullshit, or it doesn't matter because I've got so much favorable evidence in there, I win. Take that baseball analogy. Would you rather be the manager of a team running out to the field to argue with the umpire and say, they got there at the exact same time, their foot hit the bag and the ball hit the glove at the exact same time? Would you rather make that argument, or would you rather go out to the umpire and say, he was there 20 minutes before the ball got to first base? Are you blind? Now, that's not the way you talk to a judge. That's not the way you talk to a DRO. And frankly, the only reason you would talk to an umpire that way is if you're Earl Weaver. But in any event, you get the idea, and I'm doing that to illustrate the point, is that argue the stronger position. Now, to be sure, there are situations where you're not going to be able to get that evidence to a certain degree. We talked about a scenario last week where we talked about low-level flights going through the Agent Orange spray. How do you prove that there was actual exposure? That's a situation where you may have to kind of get caught up in the benefit of the doubt doctrine. But 99.9% of the time, you just don't want to go there. The better thing to do is to load that file up with evidence. And it's the four pillars. We've talked about the four pillars time and time and time again for the last 10 years. Eligibility for benefits. Service connection, to which there's three elements. Disability, nexus, right? And in-service event, current disability, and nexus. I've been doing this all these years and I get them mixed up there. And then the third pillar is the impairment rating, and the fourth pillar is the effective date. So if you put a preponderance of the evidence, and we talk about 5-star evidence, I'm not going to go into that here, but a preponderance of 5-star evidence going to each of those four pillars, you have a super strong case. And you're going to be like Stephen S. at the beginning, where you take that and lay it out in front of the judge, and they can't help but grant your claim because you have so much information and you're arguing from a position of strength. You're not out there, Earl Weaver, kicking dirt on the umpire, arguing that they got there at the same time, that they're in perfect balance. You're arguing, I beat this by a mile, right? Okay. Enough about that. I want to talk to you about another case in the world of benefit of the doubt doctrine. It's the Ortiz case. And here's what happened in the Ortiz case. The veteran, this is a confusing case to me, so I'm going to look at my notes here. But the board in that case determined that the veteran's statements about what happened to his back in service, they said, you're not really credible. Now, credible, you guys know, you've been reading the blog, you know that credibility is a $100 lawyer word. Go look it up. It doesn't mean you're lying or telling the truth. It just means that the facts don't jive with each other, right? The board judge says it's not really a credible story about what happened in service, and so I'm not going to give your facts any weight. And the medical opinions that said that this event occurred and was your current disability is related to your military service, I'm not going to give them any weight either because they relied on statements from you that I found to lack credibility. So the veteran went into the court and argued kind of essentially what I was trying to argue earlier, was that when the board finds that even there's a preponderance of the evidence against the case, when that approximate balance teeters against you, that the benefit of the doubt doctrine still applies. And if you purely read that statute, I think that's the right argument. But that's not the way it's been interpreted. It's not the law. And until we can find the right fact pattern, I don't know that we're going to be able to challenge that anytime soon. It's a tough fact pattern. I'm not going to go into it here, but it's a tough one. So the point that I want to drive home is that the court came out and kind of laid down the law again and said, nope, that's not how it works. The only time you apply the benefit of the doubt doctrine is when there is equipoise, when there is an approximate balance between positive and negative, and there has been all of the assembled evidence and all the procurable evidence, and then the board has to find reasonable doubt. So if you're arguing benefit of the doubt, it sounds like you're getting an advantage. It sounds like you're getting an edge, but you're not. It's basically the last dying effort to save a claim that's going down. The better thing to do is to plug the leak, get your C file, find out why they're denying it, and plug that leak with 5-star evidence that just overwhelms the case file. And we're going to talk about how to do that in Tuesday's webinar. We've got another webinar coming. We've got an evidence ebook up there. I'm going to teach you all about 5-star evidence in that ebook. I'm going to teach you about it in the webinar coming up in a couple of months. You know, there's a lot of stuff on the blog about how to build lay evidence. Vets like Stephen S. and many of the other vets that you see on the testimonial page have used those posts to figure out how to load their file, how to plug that leak in their claim ship. That metaphor really doesn't work, does it? Because stuffing paper in a hole, the water's still going to come in, right? Anyway, you get the idea. If I could impress upon you to take one thing away from this discussion, it is completely get out of your head the idea that the benefit of the doubt doctrine is something that works to your advantage. In the end, it does. In the end, if you truly have that tie goes to the runner, you do have that edge. But you don't want to hang your hopes on the benefit of the doubt doctrine because that means you've already lost the case. That means there's either a preponderance of the evidence in perfect balance, there's good evidence that goes against your claim, just as much as there's good evidence that goes for it. And then you've got to rely on a board judge or a DRO or a VA rater to say there's reasonable doubt. And I know a lot of these board judges, and I know a good number of DROs, and I like a good number of them, and there's a couple I don't like. It is what it is. But it is really, really rare that somebody at the board, at the DRO conference, at the rater, is going to find reasonable doubt. Why? A lot of reasons. It's hard to argue to your boss. If you have to end up paying $100,000 of past due benefits, then you have to go to your boss and up 2 levels of chain of command to get that approved, that past due benefit approved, to argue to them that this guy should get all his past due benefits. We should take that out of our operating budget or out of our discretionary budget and pay this because I have a reasonable doubt. No. They're going to cover their own butts and they're going to go against the claim. Put in a preponderance of the evidence, 5-star evidence as to each of the 4 pillars of your VA claim is the best way to do it.